Now, let's unpack this. We are diving into some really staggering allegations of organized fraud.
Yeah, and deliberate claim inflation, too.
Stuff that's reportedly, poisoning the U.S. civil justice system.
Mm-hmm.
And look, this isn't just about, like, the occasional bad apple. Our sources are suggesting we're dealing with systemic engineered misconduct, really designed to extract settlements.
That's exactly where we're focusing today. We're looking at a detailed report, and it highlights two main areas where these unsupported claims seem to be causing the most harm, real concrete harm.
Okay, what are they?
Well, first, in common personal injury claims, things like, your standard car accident or maybe a slip and fall.
Right, everyday stuff.
Everyday stuff. And second, in honestly, the vast, almost incomprehensible scale of mass tort litigation.
Huge cases.
Exactly. So our mission here is to show you not just how these alleged schemes work, but how they actually hit your pocket directly by raising insurance costs for every driver, every homeowner, every business. And at the same time, they're potentially draining the compensation pools, money that should be there for people with, genuine injuries.
And this is crucial. We need to set the context right up front.
Yeah.
All the information we're talking about,
Yeah.
terms like fraudulent stage or misconduct,
Yeah.
it's all drawn directly from public sources. We're talking court documents, police press releases, official filings, where these allegations, these findings, have been explicitly made.
Absolutely. We're just guiding you through what the records actually show.
We're reporting impartially on the allegations and what the courts have found.
Exactly. No judgment, just the facts as presented in the sources.
Okay, so let's start maybe at the micro level.
Yeah.
The anatomy of personal injury fraud.
Yeah.
This often targets soft tissue injuries.
That's right. Sprains, strains, things that are notoriously difficult to verify objectively.
Right, hard to see on an X-ray.
Exactly. Which makes them, unfortunately, perfect for exaggeration or even outright fabrication.
And what really jumps out for the sources is the coordination involved.
Oh, absolutely.
Yeah.
Look at Operation Sideswipe down in Louisiana. Started around 2016. Insurance companies suddenly noticed this, deeply suspicious spike in accidents involving commercial vehicles, almost all happening on one, short stretch of highway near New Orleans.
Wait, one stretch of highway? How does that even work logistically? I mean, how do you stage a crash convincingly?
Well, it was an organized ring. They had people they called slammers.
Slammers.
Yeah, their job was to deliberately cause the collision, usually hitting a tractor trailer, a big commercial truck.
Okay.
Then they had spotters driving getaway cars.
Getaway cars.
Yeah. And the key part was that a passenger in the car, often pretending to be injured, would falsely claim they were driving the car that crashed.
Ah, so they manufacture a claim against the commercial policy.
Precisely. A complex, high-liability claim against a company with, deep pocket.
That is incredibly premeditated. And it led to serious federal convictions, didn't it?
It did. At least 49 defendants convicted. Slammers, passengers, the whole network. And the human cost was tragically high. The scheme even escalated to include the murder of a cooperating federal witness back in 2020.
Oh, my God.
But if we bring this back to the listener's wallet, this kind of pervasive accident fraud in Louisiana, it's estimated to add at least $600 annually
$600.
to the car insurance costs for every single driver in that state.
$600 just to subsidize organized crime. That number's staggering. And we see similar exploitation elsewhere, too, right? Like Florida's PIP system.
Yeah, Florida's personal injury protection, or PIP, especially down in the Miami area, it's been a target.
How does that scheme work?
Often involves runners. These are people paid illegal kickbacks, maybe by lawyers or clinic operators, to refer accident victims.
Okay.
They steer people towards certain, let's say, corrupt chiropractic clinics. And these clinics allegedly documented wildly exaggerated pain, provided completely unnecessary treatment, and then just billed as fast as possible up to the $10,000 maximum benefit allowed by the state law.
So the goal there isn't necessarily a huge lawsuit. It's more about maximizing quick profit by churning through thousands of smaller, maxed-out claims.
Exactly. Volume. The CFO of Florida actually noted that this systemic fraud imposes an undue financial burden on every resident. Through those inflated insurance premiums everyone pays.
It bleeds into general health care fraud, too.
It does. We see other examples like that New Jersey doctor sentenced for defrauding Amtrak, billing for care never provided,
Right.
or the California workers' comp CEO ordered to pay nearly $30 million in restitution after billing, get this, $250 million for medically unnecessary MRIs, all based on kickbacks for referrals.
So when you see this level of organization, doctors, lawyers, runners, staged accidents, it really stops looking like just isolated incidents. It feels more like racketeering.
And that leads us directly to the, let's call it the nuclear option, that defendants and insurers are increasingly turning to.
Which is?
The Civil Racketeer Influenced and Corrupt Organizations Act, IFO.
ICO. But isn't that usually for, like, taking down the mafia, organized crime syndicates? Why use it in, say, a construction accident case?
Because ICO is unique. It lets the plaintiff prove a pattern of underlying criminal activity over time involving multiple parties.
Not just one single incident.
Exactly. Rather than just litigating one claim in isolation, you can show the whole interconnected scheme. That makes it uniquely suited to combat the kind of organized fraud we've been talking about. A great example is what's happening around the New York scaffold law.
Right, that old 1885 law imposes absolute liability for height-related construction injuries, meaning if you fall off a ladder on a site, the contractor is basically 100% liable.
Pretty much, which makes these claims incredibly lucrative.
How lucrative?
Well, the average settlement can top $1 million, sometimes $2 million, $3 million, or even more if there's surgery alleged. But investigators started noticing these really suspicious patterns, like dozens of injury lawsuits, all filed by people living in the very same Bronx apartment building.
The same building.
31 cases from one building. Or another example, 21 cases filed from a single two-story house.
That's not random chance. That sounds like a cottage industry for lawsuits.
It certainly suggests coordination, doesn't it? A RICO action filed in June 2025 detailed how runners allegedly recruited construction workers, offered them a fee, either to stage a fake accident entirely or to deliberately exaggerate a minor slip or fall into a, quote, lucrative full-body claim. Then they'd allegedly funnel these workers into unnecessary medical treatment designed solely to inflate the potential settlement value.
Was there like a smoking gun? A piece of evidence that really showed the premeditation?
There was. The power of attorney forms. In one ICO complaint filed by Union Mutual Fire Insurance, they actually produced a power of attorney form. It's related to the lawsuit. That was dated nearly a month before the supposed date of the construction accident.
Before the accident even happened.
Exactly. The victims signed paperwork to sue before they had theoretically even been injured. That's pretty hard evidence of staging, wouldn't you say?
You've committed to suing before you're even hurt.
Yeah.
That's shocking. And we're seeing rideshare companies targeted too, right? Uber. They have high insurance limits.
They're definitely attractive targets because of those high policy limits. Uber's filed RTO actions in multiple states now: Florida, California, New York, Pennsylvania.
What are the allegations there, say in New York?
In New York, the allegations point to a conspiracy. Lawyers and doctors allegedly working together to provide medically unnecessary treatments, specifically things like invasive spinal fusion surgeries.
Serious procedures.
Very serious, painful procedures, allegedly performed just to artificially inflate the damages value for a bigger settlement. The complaints even get into the alleged role of litigation funders, saying they advanced money specifically to facilitate these unnecessary surgeries.
And California. Similar story.
Similar pattern alleged in California. Lawyers supposedly funneling clients to pre-selected medical providers for unnecessary treatment and using legal liens against the lawsuit recovery to justify artificially inflated bills. The source cited one example where a client was just confused by all the appointments, didn't understand what was happening, and the charges ended up being like 10 times the normal rate.
10 times. And how does this impact the average person using Uber?
Well, think about this. In Los Angeles County, it's reported that approximately 45%, nearly half of the fare of every single Uber ride, goes towards mandated insurance costs.
45%.
That cost is directly impacted by this kind of alleged systemic inflation and fraud.
That's huge. Yeah. But there has been some pushback from the courts supporting RICO use, right? That Second Circuit ruling.
Yes, that was significant. A 2024 ruling that supported State Farm's RICO claim against fraudulent no-fault insurance schemes.
What was the key takeaway?
It basically cemented the idea that RICO is appropriate, even if it technically intervenes in state-level litigation, because the state courts often only seeing one individual case at a time.
Right, they miss the big picture.
Exactly. They're often unable to detect or combat the entire massive RICO scheme, as the court put it.
So that ruling kind of confirmed that when the system fails to police itself, This powerful federal law, RICO, is a viable, if maybe last resort.
A viable last resort. That's a good way to put it.
Okay, so that brings us neatly to the next scale of the problem we need to talk about. The sheer volume of claims in mass torts.
Right. The big ones. Cases bundled into federal multidistrict litigation, MDLs.
And these now make up, what, like 2/3 of all civil cases in federal court?
Roughly 2/3, yeah. It's a massive part of the federal docket now. And it's fueled, in no small part, by the incredible amount spent on lawsuit advertising.
How much are we talking?
Over $2.5 billion annually, just on ads trying to recruit plaintiffs for these lawsuits.
Billion, with a B.
Billion with a B. And this creates what's called the stockpiling incentive.
Stockpiling incentive.
Yeah, plaintiffs' attorneys have this strong economic reason to just gather claims as quickly as possible. Tens of thousands of them sometimes.
Why? To pressure a settlement?
Exactly. To pressure a global settlement from the defendant company. They often prioritize speed and sheer volume over, say, thorough investigation of each claim.
So they don't necessarily check if the person actually used the product or has the right injury.
Well, the allegation is that the screening can be inadequate because the threat of litigating tens of thousands of cases, whether they're all valid or not, is often enough to force a large payout.
And the practical result of just warehousing claims like that is pretty astounding based on the numbers.
The internal estimates cited in federal reports are, frankly, shocking. They suggest that 20% to 30% of all claims filed in MDLs are considered unsupportable.
20 to 30%.
And in some specific large litigations, that figure may be as high as 40% or 50%.
Wait, half? Half the cases might lack basic factual support. How is that even possible?
Let's ground those percentages with some specific examples from the source material. In the Ethicon pelvic mesh MDL.
What?
0.53% of the cases filed. That's nearly 25,000 individual claims were eventually dismissed. Why? For failing to meet basic factual requirements like proof of use or injury.
More than half. Unbelievable.
Another one, the 3M Combat Arms earplug litigation. They took a random sample of claimants. Nearly 3/4 of them had no record of ever actually using the earplugs at all.
3/4? That's just wasting incredible amounts of judicial resources, weeding out cases that shouldn't have even been filed.
Absolutely. Or look at the Taxotere chemotherapy drug litigation. 80% of the 16,000 claimants had never even been diagnosed with the specific injury the lawsuit was about.
8%.
And the VIOPS settlement, remember that, over 15,000 claims failed because they simply couldn't provide basic documents showing they had the qualifying injury or had even taken the drug for the required time.
So this is definitely a volume game.
Yeah.
But in some cases, it goes beyond just lacking support, right? Allegations of outright fabrication.
That's where the Uber passenger sexual assault MDL comes into the picture. Uber filed motions alleging that nearly 100 plaintiffs submitted phony or altered ride receipts.
Fake receipts.
Yeah, some allegedly generated using websites like, makereceipt.com. And the filings apparently contained obvious math errors or formatting problems.
What did the judge do?
Judge Charles Breyer didn't mince words. He granted Uber's motion, finding that 21 plaintiffs had submitted non-bona fide receipts, and he ordered them to basically show cause why their claims shouldn't be dismissed entirely with prejudice.
So fabricating evidence is one major issue. But we also have to touch on how some litigation seems to be spurred by, well, questionable research, what people sometimes call junk science.
Right. The Zantac litigation is probably the prime example here.
Okay, what happened there?
It really kicked off after a citizen petition was filed by Valigure, which is an online pharmacy. They did their own testing and claimed Zantac could degrade into high levels of NDMA, a probable carcinogen.
Okay, sounds concerning.
But then emails surfaced later suggesting Valigure was getting funding from and actually collaborating with plaintiffs' lawyers. And lawsuits based on Valigure's research were filed literally the same day the citizen petition was submitted. The timing, well, it raised eyebrows.
But the science itself, the basis for these thousands of lawsuits, was ultimately rejected by the federal court, wasn't it?
It was. The federal MDL judge excluded the plaintiff's expert witnesses in 2022. Why? Because he found they used unreliable methodologies.
Unreliable how?
Well, the lab had heated the drug, ran it to die at up to 266 degrees Fahrenheit. That's way, way hotter than the human body.
Right.
And they used basically lethal levels of salt in an artificial stomach environment to even get the NDMA to form at high levels. The judge concluded the methodology just didn't reflect real-world conditions inside a person.
So the science didn't hold up. We see similar kinds of allegations in the talc litigation too, right? with studies being questioned.
Yeah, there was one particular study cited in thousands of talc lawsuits. It alleged 75 mesothelioma cases were linked only to cosmetic talc exposure, no other asbestos source.
Okay.
But one of the defendants actually sued the study's authors.
Sued the scientists.
Yeah, alleging they knew about or at least ignored evidence that the people in the study did have other known asbestos exposures. Things like asbestos pipes in their basement, standard stuff. And the lawsuit alleged the authors were making small fortunes consulting for plaintiffs' lawyers, essentially seeking to manufacture a body of scientific literature specifically to support the litigation.
And the court made them reveal information.
Ultimately, yes. The court ordered the disclosure of the subject's name so the exposure history could be properly examined.
Okay, so if we have organized fraud, potentially rampant, courts clogged with unsupportable claims, maybe relying on flawed science, where does accountability even start?
Well, it really has to start with the judiciary. Judges holding attorneys responsible. Judge Breyer's actions in the Uber case were important there.
How so?
He denied motions from attorneys who were trying to withdraw from representing clients with those suspicious claims. He said, basically, not so fast until the fraud allegations were fully investigated.
Holding their feet to the fire.
Exactly. Beyond just judicial oversight, though, many argue that reform of the court rules themselves is critical, particularly Federal Rule of Civil Procedure 11.
Rule 11. That's the one requiring lawyers to do a reasonable investigation before filing a claim. Right?
That's the one. But it's often been called a paper tiger.
Why is that?
Because of something called the safe harbor provision. It's a bit technical, but basically if you file a baseless claim and the other side files a motion for sanctions against you,
Yeah.
Rule 11 gives the filing attorney 21 days to simply withdraw the claim. Poof, it's gone.
And if they withdraw it?
The court never even gets to formally see or rule on the sanctions motion. The misconduct isn't addressed, and the attorney essentially walks away consequence-free. It acts like a get-out-of-jail-free card for filing potentially bogus claims.
Ah, I see. Which is precisely what that proposed Lawsuit Abuse Reduction Act aims to fix.
Exactly. HR 5258. It aims to eliminate that safe harbor provision entirely and make sanctions mandatory, not optional, and potentially compensatory, meaning the offending lawyer might have to pay the other side's costs for dealing with the bad claim.
And there's other targeted legislation, too.
Yeah, bills like the Staged Accident Fraud Prevention Act, trying to make those commercial vehicle staged crashes a specific federal crime with serious penalties. And things like the Infrastructure Expansion Act, which targets the New York scaffold law issues we discussed.
So if we circle back to where we started with RICO, the source material concludes that businesses bringing these RICO actions, it's really a form of self-help, isn't it?
It really is. The report calls it a last resort and says it indicates a complete system failure where the established rules and even law enforcement haven't been enough to stop the alleged misconduct.
We've definitely covered a huge spectrum of alleged abuse here today, from, organized staged crashes in Louisiana designed to jack up your car insurance, all the way to the mass, almost mechanical warehousing of totally unvetted claims in these huge national MDLs.
And the synthesis for you, the listener, is that the financial burden of all this behavior is absolutely real. It's not abstract.
Right.
The massive costs tied up in investigating and settling these staggering volumes of unsubstantiated or potentially fraudulent claims, whether it's staged accidents against Uber or mass torts built on shaky science, those costs are ultimately passed down.
To who?
To everyday consumers, to drivers, to businesses. It shows up in the form of increased prices for goods and services and definitely in inflated insurance premiums that you pay.
So, maybe our final thought for you to explore is this. Considering the sheer volume of questionable claims we've discussed today, how does this intense pressure for quick, high-value, global settlements fundamentally change the ethical landscape, the ethical requirements of mass litigation?
And maybe what does it mean for the civil justice system's most basic core purpose? Trying to separate genuine victims who deserve compensation from, well, pure opportunism.